Do these questions ever wake you up in the middle of the night? How am I going to pay for the high cost of long-term care? What would happen to my minor children if something happened to me? If I was unable to make decisions for myself, do my loved ones know what my wishes are regarding health care? Should I have a last will and testament or a living trust? You're listening to Bulletproof Estate Planning with Estate Plan Stan, where we address these questions and many more. Estate planning is not just for wealthy people. I've made it my mission to tell everyone who will listen that estate planning is for everyone. Don't wait until it's too late. Your family will thank you. Time for Bulletproof Estate Planning with me, Stan Pierchoski, or better known as Estate Plan Stan. I'm from Pierchoski Estate Law, Pierchoski Elder Law in Pulaski, Tennessee. Phone number is 931-363-7222. And we do estate planning and we do elder law planning. Hey, I want to tell you about a couple of events coming up before I get into tonight's topics. And got a couple of my free educational seminars coming up called Wills, Trusts, and the Nursing Home. And that's exactly what we talk about at these educational seminars. First one's coming up on August the 25th. We're going to have it at the Star Theater on the square in Pulaski at 2 p.m. That's a Wednesday. We're going to just do one that day. The next one we're going to do is September the 9th, which is a Thursday. And that's going to be over at the WLX radio station, because in the back of the Lawrenceburg radio is the Country Cafe. Great big area, great big venue we can spread out in. And we can do two of them that day. We're going to do one at 2 o'clock in the afternoon and one at 6 p.m. So if you want to come to one of those, call my office at 931-363-7222 and get on the RSVP list. If you live up farther north, it's not a bad drive. It's a nice drive in the country. Come on down. One in Lawrenceburg, one in Lawrence County, one in Giles County. So come to those. Wills, trusts, and the nursing home. We're going to talk a little bit about some wills tonight. All right. Hey, I'm on my own this weekend. My wife is traveling. She's traveled several hours away to be with some family members that were in need. And she got there okay. She'll be coming back in a couple of days, and I certainly hope she'll get back safe. But we have a good estate plan, so at least I don't have to worry about that. Whenever we travel or one of us travels, because we got a good plan in place. We know our kids will be taken care of. We know property's going to go where it's supposed to go. If the unthinkable happens, or even when just something happens normally, my old and gray. But what I'm trying to bring up is, if this is summertime, this is time of people travel. The price of gas creeps up a little bit because a lot of people are traveling. So if you're going to be doing traveling this summer, you don't have anything in place, any kind of plan or any kind of documents, may want to give that some thought, because, the time it happens is when you don't have this stuff ready, right? So give that some thought, put together something. It's a good time. It's a good time to think about it. You're going to be out on the road a lot. You're going to be flying in airplanes. You're going to be traveling, exposing yourself and your family to all the other crazy drivers and stuff out there. So be safe by all means. And it wouldn't hurt to have a plan. Then leave your family out of conflict and out of court. Don't leave them with a big mess trying to figure out what's going on, or what you wanted to do, or what you intended to do, that sort of thing. So anyway, okay. Hey, just wanted to mention one thing real quick, and that is last couple of weeks, folks were trying to find me on the web, and they have trouble spelling my name. Can you imagine that? Stan. It's simple. Anyway, no, they had trouble spelling the last name, Pierchoski. But we've landed the domain called Estate Plan Stan, ESTATEPLANSTAN.com. So if you want to find my website, you want to find my information, my phone number, my email to send me a question or something, you can get there quickly without trying to remember my name. Just remember EstatePlanStan.com, and that'll get you there to my website. So, all right, listen, this is one of those nights. I'm going to talk about some wills. I'm going to talk about some serious wills. I'm going to talk about some entertaining wills, that sort of thing. I'm going to talk about some sad wills. I want to start off by talking about something that happened this week. Had some folks walk into my office, and, usually it's hard to get my attention, or gets my time if you just walk in out of nowhere, but it seems like it was late in the day. Just happened to be on a break between things. Anyway, about 5 or 6 of them walk into my office, and they wanted to know, they said somebody had passed away. They wanted to know if the will was valid. And I could tell immediately that half of them wanted it to be valid and the other half did not. I mean, I recognized that conflict instantly. And I said, well, let me take a look. And so somebody opens up their wallet. Now just picture this. I know we're on the radio. I can't show you a picture, a slide, but I'm going to describe it for you. They open up their wallet. And they pull out this little piece of paper. And it was folded up to about an inch square. And it's shoved in there. And when they pulled it out, handed it to me, I unfolded it. And here it was a page out of a 5 by 7 inch notebook, a spiral bound notebook. You know, one's got all little holes along the left-hand side. And it was torn out. So all little holes were torn. And it was written in blue ink, on about 3 or 4 sentences, maybe 5 sentences total. And there were 3 signatures at the bottom. 2 of the signatures were completely illegible. So, I mean, I looked at it and, a couple of questions came to mind. I thought, well, how do we know the testator being the author of the will or the deceased? How do we know the testator is the one that wrote this will? I mean, it doesn't say at the beginning, it doesn't say, I, Stan Pierchoski, make this my last will and testament, anything like that. It had these 3 signatures at the end, which I assume 1 was the testator, 2 were witnesses. Well, they told me who the deceased was, and I couldn't even recognize which signature was that one. And one of the witnesses' signatures apparently was, a doctor's signature. You could hardly, you couldn't tell. So also, it didn't start out by saying anything about being of sound mind. I mean, normally you state in the document, I'm of sound mind and disposing memory. What sound mind and disposing memory simply means is, what you're doing. It's a last will and testament. And understand your property or your bounty, and it's what you're doing with it. You're leaving it to certain people in certain ways, what we call the distribution. So and understand that. And if you do, then you're of sound mind to sign a legal document. Well, it didn't say anything like that. So what happened if it's silent on something like that? Well, I guess we could ask the witnesses if we could tell who they were. Even if we could read one signature was a witness, but nobody knew who it was. I mean, how do you find somebody like that? I mean, there's no address, phone number, anything like that. If I remember right, the date on the will was only less than a year. But I mean, what if it's 10 years ago? I mean, how do you find witnesses and ask them and say, hey, was this person of sound mind? And even if they seemed they were in sound mind, it's not the witness's place to make a medical decision. As an attorney, I'm allowed to do that, at least do the preliminary. We go through a test where we ask about a dozen questions. If I think capacity is an issue, we ask about a dozen questions. And if I get the right answer to those questions, and I've satisfied myself that they are of sound mind. Some folks don't even need to do the test because it's obvious, but whatever capacity raises a red flag, we go into that. The other thing that was pretty interesting about it, there was about 5 places where they had words scratched out and something written above it. Okay. And they were trying to tell me, the people that were here were trying to tell me, yeah, she decided to give some land. So she was passing some real estate. So, it was not a insolvent estate. It actually had some property, had some land, some bank accounts. I didn't talk to them long enough to know how much was in the bank, but still. So look, I'm looking at this will, and there's no self-proving affidavit or no statement of the witnesses as to how they witnessed this. I mean, were they all there at the same time? Were the witnesses in the sight and presence of each other? And were the witnesses in the sight and presence of the testator when they signed this? Again, how do we know the testator wrote it? I don't know. How do we know that those are the witnesses that signed it? I mean, the thing had every bit of being able to be manufactured. I mean, if somebody would have just wanted to write one for them after they were passed away, that's kind of what it would look like. I mean, there was just no indicia of validity to the thing. And so I kind of told him as such that I said it wouldn't, if it were challenged, it would not pass scrutiny. I mean, any scrutiny at all would invalidate that will. Any court would invalidate. Now, if everybody agreed on how to distribute the property, then maybe okay. Then you can just go and distribute it because you don't have any complaining parties, right? But when you go through probate and you publish the will, I think you'd have a hard time convincing the probate court, even if everybody was in agreement, that was a valid will. So, I told them, not a good thing to do. And, I asked about the scribbling out. And of course, I could tell by looking at some of them that my suspicions were probably too. I think they were the ones that scribbled it out because they danced around the answer. But I was thinking to myself after they left, I thought, let's just suppose this will was written by the testator. And let's say that's exactly what she wanted to have done. Let's say, everything in there was, let's not assume any evil intent. And what she wanted was written down. Okay, let's just make that assumption for now. And as she was writing it, she felt a need to cross off these 6 or 7 words in like 3 or 4 sentences, scribbled out and stuff written above. And it was always what the words that were scribbled out was actual description of the property, not like a pronoun or an adjective or anything like that that might have been misspelled. It was actual, something was, they crossed off the word car and changed it to like 54.5 acres, stuff like that. Um, so I thought to myself, even if this was valid from beginning to end, and the person who said they wrote it, and it was witnessed properly, how hard could it be to have just gone to the next sheet in that notebook and writing another one rather than and rewriting these? It was, wasn't but 5 or 6 sentences long, the whole thing. To write it again without those scribbled out words, because that of and by itself completely invalidated everything. Because the only way to change um, a formally executed will is by codicil or amendment, or just do a new one. So I thought, gee, it sure would have been easy. We couldn't have taken 3 minutes to write the whole thing in the first place. Couldn't have taken another 3 minutes just to write it with the right words in there and not have anything crossed off or scribbled out. So anyway, I'm going to talk a little bit about wills and the kind of wills that are legal in Tennessee. We got 3 different kinds. I'm going to go over them each at a time. One of them was like that. One of them was a handwritten will, just like that one. It can't have those mistakes in it. But we're gonna go through all these and see how it works. So now, if you decide you do want a will, don't do one like the one I talked about that came into my office. I mean, if you really want your stuff to go to where you want it to go and the people you want it to go to, don't do that. That's a perfect example of what not to do. So the one I talked about that came in, the handwritten one, was scratched out words and that sort of thing. So anyway, again, if you've heard me talk, I like to say wills are a step in the right direction, but just a teeny tiny small step in that right direction. I'm a big fan of trust. Wills are so limited. We talked before about wills must go through probate. Probate's a hassle. I've gotten into that before, and I'll get into it in a future show again, I'm sure. But anyway, we're going to talk about wills. Just, some folks come in and that's what they want. They say, you know what? I know what a trust does, but I don't have any kids and this or whatever. And I just think I want a will. So let's talk a little bit about that. Now, you might have also heard me say before that a will is what we call a non or inoperative document. What does that mean? It means if you have a will and you're holding it in your hand, you can tear it up, you can throw it away, you can burn it, you can scribble on it, you can do anything you want because it has absolutely no legal significance whatsoever, okay, until the moment of death, okay? At the moment of death, it springs to life and becomes a valid, now irrevocable document at the moment of death. So, and you've probably heard me say before, the will only has one purpose and one purpose only. And that is when it does spring to life at the moment of death, it conveys property to your heirs. Whoever you say in there to get your stuff is what it does. Okay. So basically, will is a testamentary legal document. It specifies how a person wants their property to be managed and distributed at their death. I mean, it's that simple. Tennessee currently recognizes 3 different types of them. Okay. One is called an attested will. I call it formally executed will. Other one is called a holographic will. And the third one is called non-cooperative or an oral will. Now, each of these kind of wills have their own drafting, their own execution requirements, and certain rules that Tennessee codified in the Tennessee statutes on what makes them valid, what has to be done. Okay, so let's talk about the attested will or the formally executed will. Now, these are the documents most of you are probably familiar with. I mean, you've seen them or you may have one. Those are the ones usually typed. They're signed, they're witnessed. Parts of it is notarized. They're the documents that you imagine when you hear the words last will and testament. And they're written out in our Tennessee code at Title 32, Chapter 1, 104. And it dictates how a formally executed will is properly executed. Now, here's requirements that 32-1-104 says has to be done. One, it has to be signed by the testator. I mean, let's not state the obvious, Tennessee, but the person writing the will has to sign it. Okay, got it. And 2 witnesses. Okay. The testator must signify to the witnesses that it is his or her last will and testament. Okay. The signature of the testator must be signed or acknowledged in front of two witnesses. Okay, so we got this requirement: the testator has to do it, has to sign it, not only sign it, but sign it in the sight and presence of two witnesses. Okay, so picture that. That's all at the same time. You don't have somebody witness it at 2 o'clock in the afternoon and then somebody pop in after work at 5 and do the other signature. Okay, I mean, the other witness. It's got to be done in the sight and presence of each other. And the witnesses must sign in the presence of the testator, and the witnesses must sign in the presence of each other. Okay. And now when I do wills, I give a little speech, and there's a self-proving affidavit that talks about what's in this speech. But basically, I'll say, okay, you are Stan Pierchoski, and you are purporting this to be your last will and testament, and you are purporting this to the two witnesses that are here in the sight and presence, and you also are purporting that you have you are of sound mind and disposing memory to dispose of your property and place it in a legal document. Is that correct? And they say yes. And I say, and you are signing it in the sight and presence of two witnesses, which is myself and witness number two. And the witnesses, myself and witness number two, we are signing it in the sight and presence of both the testator as well as the sight and presence of each other. And that's what needs to be done. That's the formal execution of it. Now, these are kind of a bare minimum. When a court's looking to determine whether a will is valid or not, these are the things they're looking for, because it's what is in the statute. So that's the bare minimum. You can put other stuff. I mean, there's other things people put in to make them, to help make them more strong, more tamper-proof, that kind of stuff. Sometimes you'll get to the last page of a will and it ends in the middle of the page. Well, you'll see sometimes some words, this space left intentionally blank, or they put an X through the blank space so that you can't pencil something in there later on. Now, I want you to notice something. When I went through the statutory requirements, you'll notice that there's no mention of signatures being notarized. Okay. People come in here all the time and say, "Hey, my dad signed a will and he got it notarized and everything, so it's okay. He's got a will already." There's no requirement that the testator have a signature notarized. It simply has to be witnessed. Now, the only time we notarize anything in a will, of course, we notarize something on all our wills, and that is we put a self-proving affidavit at the end of it, where both the witnesses sign again, and that is notarized. What that means is, if somebody wants to know what happened during that day and how this was witnessed and executed, the witnesses have filled out an affidavit. So normally we'd have to go get the witnesses and drag them into court and ask them like 5 questions. Who was there? Were you in the sight and presence of each other? Did they say it was their last will and testament? That sort of thing. So I drafted up into an affidavit, and then they sign that. So if it's 20 years later and the people have deceased or moved to Spain or, just not available, you don't have to subpoena them into court to ask them those 5 questions about what went on that day. You just submit their affidavit, which has the question and the answers. I mean, it's a sworn statement. And that'll suffice in a case like this. So we do notarize things, but there's no requirement that the testator notarize it. Because remember, notarizing doesn't validate anything. It simply shows that the person had to provide proof that they were who they were. So when I sign my name and it's notarized, somebody just proved that I am Stan Pierchoski. I produced documentation to show who I am. Common mistake. It depends on whether witnesses are disinterested, that sort of thing. If a witness is interested, they don't make a very good witness. You need to put more. Interested meaning they take under the will. So if you're one of the beneficiaries, you're going to take, not a good idea to witness it. That's a good argument to invalidate that. Anyway, these are important things, and a lot of them are commonly overlooked because not many people go read the statute, right? They call an attorney, and who knows what they tell them. So, if you want to do a will like this, you need to talk to somebody like me or talk to me, and we can draft a will for you. And it'll be one that's tight. We'll make sure all these requirements are done. We throw a few extra ones in there to make it almost impossible to challenge. We'll talk about what you've done in there and make sure that you haven't created areas where things can be challenged, because that's what we want. So if you're going to do a will, like I said, I'm a big fan of trust. They do the same thing and they do it a lot better. But if you decide you want a will, we want to make sure it's bulletproof too. So, all right, that's the formally executed will, or the attested will. That's the one everybody's used to. But there are 2 other ones recognized in Tennessee. One is called a holographic will. Now, these are handwritten wills, like the one I talked about. Handwritten wills are recognized in Tennessee. They're actually codified under 105. So, 32-1-105, the very next statute after the attested wills. Generally, I mean, the only real formal requirement establishing a valid holographic will is that it has to be signed by the testator. I mean, that's a gimme, right? All the material provisions of the will must be in the handwriting of the testator. So, you can't be half typed, half handwritten, or handwritten by somebody else. It means what it says. So it has to be in the handwriting of the testator. And the testator's signature must be proved by 2 witnesses. So that's all that's in the statutes. That's all that's required. Did the will that came in my office the other day satisfy this? Not really. Too many areas of challenge. So, handwritten wills are not entirely uncommon. They come up from time to time. They're not, I mean, I guess they're not real common, but they're not as uncommon as the next category I want to talk about. Let me put it that way. But they tend to be more open to will contests. Okay. And they're mostly open to a will contest on the basis of what we call undue influence, or lack capacity. Like I was talking about the one that came in, fraud, somebody just trying to get a piece of the pie, right? Or if you have ambiguous language, okay, like the crossing off of words and writing above them. It's usually caused by several factors. So not a good idea, handwriting. I think the problem with a handwritten will is I think if everybody agreed, it would fly. But if somebody was disgruntled and wanted to challenge it, I think probably 99% of the time, it would not survive any scrutiny. So anyway, if you want to write a will, I mean, handwritten, just make sure you do it. Make sure you sign it. Make sure it's all in your handwriting, and make sure you sign it and it's proved in front of 2 witnesses. All right. So let's talk about the lack of witnesses. We were talking about that. Handwritten wills, they have to be witnessed at the time of signing. At first glance, testator's going to feel as if they're getting away with the annoyance or the organizing of the formal will signing. A lot of people like to do this because they don't want to go through the formality of the attested will they talked about. But they're missing the primary importance of having witnesses. I mean, that's evidence that the testator, like I said before, is of sound mind and disposing memory, and that they're not being coerced into signing their name to the document, and that no one's forging their signature. Or authenticity of the testator's handwriting adds additional time and expense to an administration process if somebody's trying to challenge it. So vague language. I mean, when you write it out by hand, sometimes you can be pretty vague in what it is you're trying to convey. If there's any ambiguous language, unfortunately, we got the testator who's not around anymore to clarify what his or her wishes are. I mean, it can lead like named executors. I mean, how are we going to know who the executors are if you're not clear in the language that's put down there? All right, we talked about the formally executed will. We talked about the holographic will. Now we're going to talk about what is called a non-cooperative will. Odd name, but you can just think of this as an oral will. Yep, that's right. Oral, meaning you just say it. Now, they're kind of an oddity in Tennessee, and they're pretty much useless, and you'll see why in just a little bit. I mean, well, let me put it this way, they're extremely limited in what they can do, and rightly so. An oral will just lends itself to abuse, right? So anyway, they're limited in their power in just about every regard that I'll go over here. They're governed by our code at 32-1-106. That's the next statute in line after formally executed and holographic. And that 106 tells us how to create them, execute them, and their validity. Now, here's what it takes to do an oral will. It can only be made by a person in imminent peril of death. Okay. So, I mean, you got to be dying from something. Now, get this. And it's the oral will is only valid if the person actually dies of that peril. So let's think about this. Let's say, you fall off a ladder, you break your back, you're hurt bad, you think you're dying, somebody's there, you make this oral will. It's only valid if you die from that. Now, what if you recover from it? If you recover from it and 5 years later, you actually do pass away, and somebody says, whoa, 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 wait a minute. He said I could have that. It was 5 years ago. No, that invalidates it because you have to be in imminent peril of death and you have to actually die from that imminent peril. All right. The oral will has to be declared before two disinterested witnesses. Now, there's a qualifier on that. It can't just be two family members around your deathbed. It has to be two disinterested witnesses. I guess it could be a family member if they didn't take under the will. Okay. All right. They have to be put into writing by one of the witnesses within 30 days of death. So, that's kind of obvious, that before people forget what was said, it's got to be reduced to writing within 30 days by one of those two disinterested witnesses. It also has to be submitted for probate within 6 months of the death. Okay. So you got to get into probate. Now, here's one of the real limiting factors of it. You can only dispose of less than $1,000 of personal property. So no land, no real estate. You can't pass a family farm with an oral will. You barely can pass. You only pass $1,000 or less, which is pretty trivial. And the last thing here is also pretty limiting, where it says you cannot revoke or change an existing will. So it's sort of just something that kind of like a supplement to the will that you have. So it doesn't really change the will you have. It just does some last minute fine tuning up to $1,000. So there you have it. That's the oral will. Definitely a rarity in Tennessee. I've never heard of one or dealt with one. Saw it on the bar exam 20 years ago, but other than that, so okay, those are the three types of wills that are recognized. And what I want to do now is go over some wills that I hate to say are humorous, but I think they're interesting. Some might be a little humorous, but some are just circumstance driven. Some oddities put in wills, some strange requests or demands, or weird places to leave their property, or vindictive ways to leave your property, or uh, you know abusive ways, really. So anyway, let's talk about. There was a gal by the name Leona Hemsley. Okay, she was pretty famous. She was multimillionaire. She was in the hotel. She was what they call a hotel mogul, and she had quite a bit of money. And she left in 2007 when she died. She had a will that left $12 million to her dog. It was a Maltese pup by the name of Trouble. So anyway, Trouble inherited $12 million. And the thing that was vindictive about this is that was $12 more than her two grandchildren received. Okay. So anyway, those two grandchildren contested the will. They went to court and contested it. It turned out that the court cut the dog Trouble's inheritance down to $2 million and pretty much handed $6 million over to the girls. But anyway, from what I was reading, the Trouble lived a pretty good next 4 years until the dog passed away in 2011. So anyway, let's talk about leaving money to animals. A couple of weeks ago, I talked about what we call pet trust, and you can leave money, but you can't leave it to the animal. Okay, here's why: a pet is property. I know there's some pet people out there that love their pet, and I've got a couple of Labrador retrievers, and I love them too. But legally, they're property, and they're governed by property laws. So theoretically, legally, property cannot own property. So you can't leave money to a dog because they lack the capacity to manage it, spend it, do anything with it. But you can leave it like in a trust for the care and upkeep of that animal for the rest of its life. So if any of these, some of these ones on giving to animals may be defective for that reason. They weren't very clear in the dissertation that I was reading. So, all right, Harry Houdini. Remember Harry Houdini, the illusionist, the magician, escape artist? That was his big thing. He had some final wishes that he wanted to put in there. And his final wish is that he requested his wife, Bess, conduct a seance each year on the anniversary of his death to see if he could communicate from the other side. And he left a code for her. The code he left for Bess to read was Rosabelle, answer, tell, pray, answer, look, tell, answer, answer, tell. Anyway, unfortunately, every attempt that was made, I think they did it for she did it for 10 years afterward, and then she gave up trying. But all 10 years, it failed. But some others, I understand, took up the tradition, and it still goes on today. People are considering, you know, Houdini, trying to get contact with him, to even today. He died on Halloween, so of all days, but he died on Halloween for how Harry Houdini, and they're still trying to make contact with him. So, and another thing is when you have requests like this. Now, that's not leaving property to somebody. When you leave a request like this, they're not really enforceable by law. So, Houdini's widow, I mean, she wouldn't lose the house or she wouldn't lose any of the property if she didn't perform the seances. She probably did it out of, love and respect for the husband, but you can't enforce that sort of thing, those kind of actions. So, all right, here's here's a good one that I like. I don't really know this guy. His name is Henry Heine, and he died away some time ago, 1856. So you don't know much of him, but he was he left. This is classic. Uh, he left his entire estate, which I think was pretty substantial. I'm seeing if I wrote down how much it was. I think it was almost a million. 1856. That would have been quite a bit of money. But he left his entire estate to his wife, Mildred. I'm sorry, Matilda. Now, that doesn't sound too odd. You're going to say, well, gee, most people leave it to their wife, right? Well, you would think so, wouldn't you? Anyway, there was a condition on it. You get all of it. You get the entire $1 million estate, provided she remarried. Okay, so it's why that condition? Well, Hines he put it in his will that the reason I'm doing this because then there will be at least one man to regret my death. God. I think that's hilarious. So Matilda, who knows what kind of person Matilda was, but Mr. Henry Kine thought if she remarried, at least somebody would miss him. All right, here's a gentleman named Luis Carlos de Noratha. Outside of having a long name, he was a pretty wealthy Portuguese aristocrat. He didn't have any children, or he didn't have any friends either. So he must. I don't. Well, it says a lot about his personality. But when he drafted his will, he just randomly picked 70 names from the Lisbon phone book, just random. So those people, 70 lucky strangers, received portions of his fortune, estimated to be several thousands of euros each. So I guess we got no other place to put it. That's as good as any, right? All right. English philosopher Jeremy Bentham technically died in 1832, but I say technically in 32 because he's still hanging out in the halls of the University College in London. In his will, he instructed that his friend, who was also a doctor, a medical doctor, was to preserve his head and skeleton. This is getting kind of weird, but anyway, preserve his head and skeleton, dress his remains in his suit, seat him in a chair with his cane, and display him in a cabinet or case on the university campus with a placard that read Auto Icon. So Bentham they did that. Bentham's actually been there since 1850. And if you want to go, there's a website. He's got a virtual 360-degree rotatable version of the guy. So I didn't go to it. No thanks. A little bit too weird, too morbid for me. But, if you can't make the trip there and you want to look at it, you can go ahead and do it. So anyway, they actually it did say replaced his real head with a wax one, partially due to two reasons. One, some decay, which I guess would certainly happen. And the other one, this kills me, due to the fact that the students were kept stealing it all the time. College kids. I guess they're the same anywhere, right? So, all right, let's see. We got another one. Sandra West. She was an oil heiress, and she died suddenly at age 37. And she wanted to be buried in a white nightgown in the front seat of her 1964 powder blue Fiore 250 GT. And so she was. But when they buried it, they cast it in concrete so that it would discourage looters. So a whole car, buried inside a whole car. So, all right, we're talking about strange wills, and I mentioned one about Leona Helmsley, that hotel mogul that left $12 million to her dog and nothing to her grandchildren. If you thought that was spiteful, there was this attorney in Iowa. His name was T.M. Zink, spelled with a K, Z-I-N-K. He died in 1930. He left $5 to his daughter, nothing to his wife, and he set aside the rest of his entire fortune for a so-called womanless library. Basically, what this says, we had books that were written by men, and no ladies were allowed on the premises. So anyway, this sort of, that thing wouldn't fly too good these days, but it was kind of sexist, and this thing never really saw the light of day, and there was never such a library built because Zink's family successfully challenged the will in court, and it was never built. Now, you might listen to that and say, well, he was a sexist. What a terrible thing to do. When I read that, what I see is that his family successfully challenged the will in court. Now, I'm not referring to what he had in the will. What I'm saying is, I've been saying it just about every Sunday night I'm on here. Wills can be challenged at the drop of a hat. Anybody can challenge a will for any reason in probate court. And who needs it? You want a document, it's not going to be challenged. It's going to do what you want it to do because you wrote it like a trust. So all these wills were probably challenged because definitely somebody was not too happy about the way the property was left. Here's a good one. This Canadian millionaire, his name was Charles Millar. No reason you should really know of him for any reason, but he was known as a bit of a prankster. But anyway, he didn't have anybody really to leave his wealth to, and he had quite a bit. If I remember, it was like $8 or $9 million. So he decided to leave his entire fortune to whichever woman produced the most babies in the 10 years following his death. So they had an actual challenge, like a contest to do this. But anyway, after 10 years, it actually was split 4 ways to 4 women who each had 9 children in those 10 years, I don't know if they had 9 children trying to win the pot, but some of them may have. But anyway, that's where that went. Let's see. We got a guy named Londoner Henry Budd. He was a beard or bust kind of guy. I mean, he loved beards, but didn't like, as far as facial hair, but did not like mustaches. Because in his will, he expressly forbade his 2 sons from growing mustaches. If either of them sprouted a mustache or a handlebar mustache, his share of the inheritance was voided and would revert to whichever son had retained clean shaven upper lip. So again, probably not enforceable, but definitely expressing what he wants. You can't really require somebody to have a mustache or not. I guess you could wait and get your inheritance and then grow it the next day. So anyway, all right. So let's see. Okay, that's probably enough of those. I look through here. Some of them are kind of cute. I want to go over a couple situations where the will kind of didn't go the way we wanted it to. Not really horror stories, but a situation where somebody's estate planning had a will or didn't keep it updated and things didn't go the way they wanted. So there was a Hollywood filmmaker by the name of John Singleton. He was kind of a celebrated director, producer kind of guy. And he slipped into a coma somewhere around 2019. And while he was unconscious in his bed, his family discovered that he never created a medical directive or power of attorney, in case he was incapacitated like this. So it sort of sparked a family battle over guardianship right away. Now, you've heard me talk about power of attorney and power of attorney for healthcare directives. Anyway, 13 days later, Singleton died. He passes away. And the family was just, horrified to find out that he never updated his final will, which was created in 1993. Okay, so let's see. He died roughly in 2019, 93. That's almost pushing 30 years, 27 years ago. So turns out in the 26 years since, Singleton fathered 6 more children with different women. But he never updated his will in 26 years. He never updated to reflect the additions to his family. So his estate was estimated to be like $38 million. Now, that kind of fortune at stake, there's undoubtedly be some infighting and ruined relationships as the family packs up and goes to war over their portion of the estate. Okay, so when you don't keep these things updated or don't have them in the first place, you are gonna put your family in conflict and in court. All right. Another one is it's pretty important to give decision-making power in a will to somebody that's trustworthy and capable. When you name an executor in your will, make sure it's somebody that's, it's not the wrong person for the job. Make sure it's somebody who'll do it. It's a fiduciary duty, and a fiduciary can abuse their power or let greed overtake a sense of responsibility, that sort of thing. So, here's a gal named Beverly. I'm going to try and pronounce this last name, Schottenstein. Beverly Schottenstein. She was 91. She was the wife of a department store mogul who trusted her financial advisors, which were her grandsons. She had two grandsons. She trusted them with an $80 million estate of hers in her assets in her retirement years. Okay. $80 million she gives her two grandsons who were financial advisors to manage her money. She designated them as fiduciaries so that even when they would change firms, her account would move with them. So, they were the actual fiduciaries. So, okay, but unbeknownst to Beverly, her grandsons kind of exploited her. What they did was they started placing these assets in risky investments just so that they could earn these big commissions. You know how financial advisors work. They get paid off of commissions and when they buy and sell stuff. And so they started putting them in all kinds of things that had high commissions and were self-serving. And she was in an interview that she had stated that her grandsons made a number of what she called extremely complex and highly risky investments that were worth more than $72 million. And it, according to her, it led to the loss of more than $10 million. But she said it yielded the people, her two grandsons and J.P. Morgan, who was the investment firm they worked for at the time, hundreds of thousands of dollars in fees. They also charged a lot of money to her credit card. Get this. Her fiduciaries were charging purchases to Beverly's credit card each month. They were doing it so much. They did so much of it to the point where her bank account was frozen due to too much activity. So anyway, she had to go to court and fight over this thing, and she got some relief, but and she said, the family was close. They were very close. The entire family was close, but that just destroyed everything. It just wrecked it because she didn't pick the right people. So unfortunately for Beverly, but what was interesting? She said, she made a comment that I thought really stood out. She said, if these boys would have just done what I asked them to do, they stood to inherit a ton more than they made in the commissions that they were when they abused the authority. It was a $38 million estate. They were going to be millionaires, and they just received a couple $100,000 in the commission. So it was kind of a waste. All right. Well, listen, I got more of these, but I'm going to sort of start to wrap it up a little bit. And that is, I want to go over these events I got coming up. We had a little fun, tonight talking about some of these estates and stuff like that. But it's serious business. It really is. And if you haven't got some kind of plan, you need one. You need some kind of plan. So if you don't know anything about it and you're thinking, gee, where do I start? Listen, I do these free educational seminars. And that's what they are. They're free and they're educational. I want you to know what a will does and doesn't do. I want you to know what a trust does and doesn't do. I want you to know what the irrevocable asset protection trust does and doesn't do. Once you know that, then you're in a position to make an informed decision, right? If what you heard this week has piqued your interest, I'm glad. My mission is to get the message out that when it comes to estate planning, you have options, lots of options. If you have any questions about your own circumstances, I'm more than happy to take the time to answer. You can call my office at 931-363-7222 or send me an email at stan@pierchoskiestate.com. That's Stan, S-T-A-N, at P-I-E-R-C-H-O-S-K-I, estatelaw.com. Visit my website and check out where I'll be giving my next free educational seminar. My website is www.pierchoskiestate.com. Thank you for listening to Bulletproof Estate Planning, and I am Estate Plan Stan.